previously the House of Lords, the judgment of Lord Wolf, CJ, had the following to say: we believe the modest adjustment in R versus God is called for, which makes it plain that it is in effect not different from the test applied in most of the Commonwealth countries and in Scotland. The court must first ascertain who was biased. It must ask whether those circumstances could lead a fair-minded and informed observer to conclude that there was a real possibility or a real danger, the two being the same, that the tribunal was biased. The President of Republic of South Africa versus South African Rugby Football Union, 1998. The Supreme Court said, at the very outset, we wish to acknowledge that a litigant and our or his counsel who find it necessary to apply for the recuse of a judicial officer as an viable task, and that the propriety of their motives should not lightly be questioned. Where the grounds are reasonable, it is the counsel's duty to advance the grounds without fear. On the part of the judge whose recusal is sought, there should be a full appreciation of admonition that she or he should not be unduly sensitive and ought not to regard an application for his recusal as a personal affront. So that an application for recusal of a judge in which actual bias is established on the part of the judge will easily be taken, but on bias, on really danger, then there has to be evidence enough. The Supreme Court of Canada also expanded on this. In one of the cases, said the apprehension of bias must be reasonable, held by reasonable and right-minded persons, applying themselves to the question and obtaining thereon the required information. The test is what could be an informed person viewing the matter realistically and practically, and having thought the matter through, will conclude. This test contains a twofold objective element. The person considering the alleged bias must be reasonable, and apprehensive of bias itself must also be reasonable in the circumstances of the case. Now, coming back to the case before me, as I said earlier, the issue was failure by the court to have the case person attend all the mentions and hearings. That's the main lamentation by the complainant. I have a release of this file from November 2021 when I took over this matter. I note that there were preliminary applications from the beginning, and objections, and more importantly, mentions were taken for the purposes of the trial. Also note that while the second accused appeared in all dates set by the court, the first accused had medical issues. According to the records of 11 January 2022, the court was informed that the first accused was indisposed, and the counsel undertook to avail evidence of indisposition on 14 January 2022. He was still, come 2022, he was still on bed rest, and the prosecution had no objection taking another mentioned date. With the complainant, all the days the first accused had failed to attend court, there was corresponding reason. The prosecutor did not oppose the reasons for his non-attendance. Instead, the prosecutor at all times said there is no objection until the documents are closed, and thus it did not apply for the warrants of arrest against the first accused. Honestly, I do not see any biasness or impartiality on my part as the presiding magistrate, even as the proceedings can bear me out. I want to talk on the constitutional petition that was in the High Court. Come 2023, constitutional petition number E027/2023 was filed, and consequently, these proceedings were frozen till 13th of October 2025, when the court was served with an order of withdrawal of the petition. The High Court issues a stay proceedings the order freezes the case completely in the lower court. The subordinate court loses jurisdiction to continue with the matter until the stay is either lifted or concluded. A stay order means, therefore, that the case should remain as it is. Ideally speaking, all hearings, rulings, mentions, directions, or administrative actions has to be stayed or have been stayed by the order of the High Court. Put differently, when there is a stay from the High Court, the subordinate court jurisdiction is temporarily removed from the subordinate court, and every step made is a nullity. A fair mention to confirm the status of the orders of the High Court may be permissible, but it is not mandatory for the accused persons to attend court. Their counsel can inform the court the progress of the petition. Let me talk about the participation of complainant in criminal proceedings. It was argued that the complainant cannot be a secondary prosecutor in a criminal case. In other words, a complainant cannot usurp the constitutional mandate of the office of the DPP, and the Supreme Court decision of Joseph Redrix Warsaw has transformed the old participation of the complainant in a criminal matter, unlike during the lifetime of the retired Constitution of Kenya. The approach now is transparent, and the complainants have rights to address the court in assisting it and with the leave of the court. The reason why the leave of court must be sought is to avoid trespassing into the independence of the ODPP in criminal matters pursuant to Article 156 of the Constitution. The guidelines have been set out also by the Supreme Court in Warsaw case on how the complainant can enter into the arena and to what extent or manner he can participate in criminal proceedings. So that in response to this, the complainant said that the application affects the recusal of the trial magistrate, and so it is a procedural issue and does not require the participation of the prosecutor. I agree not. This is one. It is a preserve of the ODPP to control criminal matters. Number two, under Section 9 of the Victims Protection Act 2014, the complainant/legal representative must apply for leave to participate in the proceedings. And number three, being a criminal case, Article 156 does not pass jurisdiction to the complainants, even in matters of procedural applications such as the one which is before me, without involving the prosecutor. Finally, in respect to this application, I want to rely on the decision by Justice William Musyoka in the case of Murunga versus Republic of Kenya. This is Criminal Revision number 1 of 2025, which was delivered on 17th November 2025. This is what it says. In criminal proceedings, prosecution is at the instance of the Office of the Director of Public Prosecutions, except for private prosecutions. And Article 157 of the Constitution, the ODPP is vested with more or less exclusive jurisdiction to conduct public prosecutions. Matters are reported to the police, who conduct investigations and present their findings to the Office of the ODPP, who then initiates prosecutions on behalf of the public. In public prosecutions, the parties are the Office of the DPP, usually styled as the Republic and the accused person. The complainant is not a party in a criminal matter, but is treated as one of the witnesses for the prosecution. The law does allow limited interventions by the complainant, where it could be permissible for a complainant to instruct an advocate to waive brief the proceedings, working together with the Office of the DPP. The views of the complainant could also be taken with respect to bail bond and sentencing. Beyond that, there could be little room for the intervention, for the prosecution is driven by the ODPP. The complainant cannot, for example, appeal against the verdict of the trial court. If he is aggrieved, the ODPP could file the appeal on its behalf. I doubt the complainant could have basis for seeking revision of any decisions of the court. In my humble view, to allow interventions of that sort could cause confusion, and it has the potential of undermining the role and the function of the office of the DPP. In that respect, there could be merit in the argument by the office of the DPP that there is something fundamentally wrong with the application. The application hearing was mounted by the office of the Director of Public Prosecution as a public prosecutor. It was not initiated by the complainant as a private prosecutor. To that extent, the complainant is not a party to criminal proceedings before the trial court, as he is not a party to the criminal proceedings, and as she is not the prosecutor, she could have no standing to seek sort of the order sought in the application dated 30th of April 2025. Those orders can only be sought by a prosecutor. I am talking about consolidation of suits, stay of criminal proceedings, and transfer of one case to another court. The decisions on these kinds of matters should be at the sole discretion of the ODPP, who need not consult the complainant on them. It is not even within the province of the complainant to apply to court to ask a presiding judicial to recuse themselves. That ought to come from the prosecution. To allow a complainant to seek these types of prayers or to intervene in that kind of a manner could be weaken the hand of the office of the DPP and to undermine the independence and the discretion that the office of that office. Consequently, it is my finding and holding that the complainant had no standing to make the application dated 30th April 2025 for recusal of a judicial officer, so long as the prosecution of the criminal case was at the instance of the office of the DPP. The application was therefore improper and incompetent. It was a usurpation of the constitutional and statutory role of the office of the DPP, which should not be allowed to stand, and the practice of filing such applications ought to be discouraged. End quote. In disposal, I find that the prosecutor did not even participate in this application, and on the strength of the cases of cited above, together with the application with the orders of Justice Musyoka, I make a finding also that the notice of motion dated 6 November 2025 is effective and is yes.
The first request, Your Honor, is that if you can upload a copy of this ruling, Your Honor, to the CTS portal, we will highly appreciate it. And then to Your Honor, you notice that this is a fairly old matter, and speaking for self, Your Honor, we have had different advocates representing the first accused, so our documents are all over the place. We would request that if you so consider, Your Honor, that if the prosecution can upload the documents they rely on during trial, also on the CTS, so that all of us can access them. I'm sure they have them, it's just to upload them on the CTS. We would really appreciate that, Your Honor, so that we put our documentation in order. Because I have documents, but the numbering and the ordering, they are all over the place, Your Honor. So if the prosecution can be kind enough to upload the documents they rely on the CTS for us to access them, Your Honor, that will help. Otherwise, we thank you for the ruling, and we request that we take early hearing dates. We expedite on the hearing of this matter, Your Honor. We can take several days, maybe 5, so that we complete the prosecution's case, hopefully. That's all, Your Honor.
Yes.
For the second accused person, we find great wisdom in your decision. You have confirmed the presence of the complainant in court, as well as the other prosecution witnesses. As my learned friend Mr. Nyongesa has indicated, and we can take multiple days for hearing. I hope that the court will find room. It's very busy schedule to accommodate us that time. Most
the complainant, there's some which are quite lengthy. I don't know, maybe perhaps with your guidance, you can decide if you'll finish it in the new term, in this term or the new term. Your Honor, also on the issue of uploading the statements on the CTS.
Just a minute, I do not get you clearly. So you said you're able to complete it within this term?
Your Honor, already our course list is quite full until the 3rd.
All right.
Perhaps you can provide guidance on that. Yeah.
What about the documents that Nyongesa is asking for?
Your Honor, we had already made copies of the state, and we had actually agreed with that this person to go and collect them at the station. May not be possible for me to upload them at the CTS now.
Okay.
Yeah. Since we had earlier provided them, and there is an inventory in a police file on them having picked the same document, provided at their own cost, since we had earlier provided them. Your Honor.
What do you say, Mr. Nyongesa?
I hope it's one complete copy of all the documentations so that we can do the photocopy, or at least the pen as well, we can access them. We have no problem doing them at our cost.
All right. I have a short time. You need those statements also. So I don't know how much time you take to get them.
As long as they are available, I can get them within a day. So I don't know when the prosecution can pay them.
Maybe that can new. On part of the defense, I think we are on our part sufficiently ready. Even if we get the statements, I don't think there's anything new that will be coming up. This matter has already been litigated at the High Court. And I think maybe it will just be a very short time. We get the copies, we confirm that we have them, and then we proceed. I don't think there'll be anything new. This matter has already been litigated.
So it is. Is it okay?
I'm okay with 4th, 5th.
5th is not convenient.
4th is okay for me.
8th and 9th, yeah.
8th and 9th.
8th is convenient, 9th is not for me, Honor.
That should be the last day I think I'll be hearing any matter in this court.
9th?
We can take the 4th and the 8th, Your Honor, for this term.
Alright. So it's, I think that's all?
Yes, I think that's all.
Thank you, Your Honor.
Thank you, Honor. Most of life.
Yes.